Commonwealth v. Anthony Eugene Jessup.
Thank you. Good afternoon, Your Highness, or
Still
getting
morning.
close to afternoon.
Still morning.
My name is Elaine Perinsky, and I represent the appellant defendant, Mr. Anthony Jessup, a young man who was convicted of first-degree murder based on felony murder. I am sure you know from my brief that I've addressed two issues in the brief. The motion to suppress, which was denied by Judge Sweeney, and whether the defendant should have received an involuntary manslaughter instruction. Just to give you a brief facts in this case, there was a party at a bar, and it was sort of an open invitation kind of party. A number of people went. People were milling about outside the bar. It was sort of a black dress party where people would dress in black clothing. The defendant and the co-defendant were allegedly seen walking around this party, and then at some point the victim, who was parked across the street in a sort of a darker area, two individuals allegedly approached the car, and the victim was shot in the car. There were some inconsistencies, which I'll get into in my later argument, about what was said to the victim, if anything, and also whether, there was also a crash involved here, whether the crash occurred first before the shot or the shot occurred before the crash. But first I'll address the issue of the motion to suppress. The defendant and his girlfriend were traveling in Virginia. They were stopped by a state trooper there, and it was determined that there was a warrant out for the defendant, and also the girlfriend was held on another matter, and they were brought to the Southside Jail in Virginia. And the defendant had been there less than 2 weeks, and while he was there, he attempted to send a letter to his girlfriend, who was in the female part of the jail, totally separate. You don't see the females ever. Males and females just don't interact at all. So there were two ways you could send mail. Either leave it at your, they don't call it a cell anymore, they call it a pod, or on the windowsill of the pod. And he left the letter on the windowsill of the pod, and the official of the jail comes by and collects the mail. And he noticed that this particular mail was being sent to a female in the female part of the jail. So he stamped the mail void, returned to sender. Now there was no question that he knew who had sent this mail, or who was attempting to send the mail. He wrote down 505, which was the defendant's number of his living area. He heard another inmate say to the defendant, they have your mail.
Counsel, are you challenging the policy or its application to the defendant?
I would say both, but mostly its application in this case, because it was, one, it was not neutral, and two, it was selectively implemented because the girlfriend had actually sent a letter to him.
Well, why don't you help me understand first why the policy is constitutionally infirm? That's the first question that I'm not exactly clear on from your brief.
Okay, well, if we look at the Turner case, it sets out the factors. Valid if related to a legitimate penological interest, rational connection between the regulation and legitimate government interest, alternative means of exercising right that remains exercising the rights that's open to the inmates, and impact accommodation of that right. We can start with the accommodation part in this particular case. All it was, inmate mail was allowed, but you had to receive permission to do it. So an easy accommodation of that, the First Amendment right, was to just send it back to the inmate, and it was stamped, return to sender, and tell that inmate, you have to get prior approval for this. It was a...
It says so in the policy, though, doesn't it?
It does, but he was a fairly new inmate, less than 2 weeks. He was pretrial. He wasn't a convicted inmate here. We have a pretrial individual here. And his girlfriend had sent him a letter. So I assume, or it can be assumed, that he thought he could send her a letter back. So
now you're talking about the application. I just want to be clear on what is the constitutional problem with the policy?
Well, even and the Commonwealth cites it in their brief at Addendum 7, I believe on page 29, the reading of inmate mail for under the Virginia Code. Procedures shall ensure that inmate mail shall not be read except when there is a reasonable belief that there is a threat to the facility, order, and security. And in this case, so they go against their own Virginia policies. So in this case, we know there was no threat. How do we know that? We know that because the testimony of the person who opened the mail conceded during cross-examination that if opened, it was not a security threat. The Commonwealth, in their addendum, in their footnote, acknowledged that the threat to security did not play a role in the confiscation of this mail. We know that various cases look at were there gang symbols. Was there any evidence of gang affiliation? We don't have that here.
Doesn't the not opening mail, I can't find exactly your reference, but if the mail itself is contraband because the permission wasn't sought, doesn't that put it in a somewhat different category?
I think there was a question whether this was even considered contraband. There was nothing in the policy which... I'm sorry?
Didn't the officer testify to that?
Well, he testified to that it was contraband. He called it contraband, but we can call anything we want to call it. I mean, but there was nothing in any policy that stated mail was contraband. Again, the Commonwealth in their own brief put a definition of contraband, which is not fitted here, and the individual who confiscated the mail, when cross-examined about contraband, he gave a definition of it, something that is altered from its original state, which this wasn't. This was a letter. It could easily be felt, and to see if anything was inside. And when asked, well, give us an example of something that was altered from its original state, he gave an example of a pen, a flex pen that could be put in a card, which presumably could be used as a weapon. So even in his own response, he couldn't give a definition or fit this into something that's called contraband. And in our own experience, we think of contraband as drugs or something that's sent to the inmate of personal...
And that's not permitted. I mean, in this context, it's something that's not permitted, isn't it?
Right, but there was an easy, I can't concede that it's contraband, but it was an easy remedy to this. And apparently he was going to do the remedy, which was return to sender. And there's obviously a stamp there, return to sender, which they must use at times. And for some reason that was changed. There was an easy remedy which doesn't affect the jail at all, doesn't affect other inmates, to accommodate what is a First Amendment constitutional right. I mean, an inmate doesn't lose all of their rights because they're inmates. And again, this is a pre-trial, non-convicted inmate.
How was he harmed by the failure to suppress the letter?
How was he harmed?
Yes.
By the judge's failure to suppress the letter?
Yes.
Well, this letter contained incriminating information.
And what was that?
Well, it basically said, the victim looks, like we're in good shape. The victim wasn't killed by the it looks as though the victim was killed by the accident, not by the gunshot. And there was some statement in there about being broke. So it clearly harmed the defendant in this case. And Judge Sweeney, who I think is normally an extremely thorough judge, sort of focused on the stop and not really on the mail. And she said, well, if there's the threat, but it was almost an afterthought for her. But if you look at it, there was clearly no threat here, and that was conceded by the Commonwealth, that it wasn't confiscated because of any belief that there was a threat to anyone.
Well, are they supposed to do an individualized analysis every time there's a question mark about whether or not correspondence is in conformity with the policy? I mean, they already knew that this wasn't sent in according to policy. So are you saying that even in spite of that, they were supposed to decide whether it was okay to send it anyway?
No, I think there was an easy accommodation, which was to walk a few steps, return the letter to the inmate, and say, you need to get prior approval for this. And again, it was selectively enforced because the girlfriend got to send the letter. So is your constitutional right based on which person you happen to get that collects your mail? It seems to be here. And again, I would point to what the Commonwealth wrote in the brief of the Virginia Code that, that it's not a policy to read an inmate's mail. So
one wonders about, I'm not going to get into an in-depth analysis, but there's two kinds of mail, obviously, inmates receive. Mail from the outside and then inmate-to-inmate mail. And they seem to be dealt with separately in the regulations. At least with respect to inmate mail, not only does it have to be pre-approved that those inmates can communicate, but it says such correspondence at institutions of all security levels may be inspected and read by the staff at the sending and receiving institutions.
right, and it may
Inmate mail.
It may very well have been denied that he would be allowed to send the mail out. So that's not the question, whether he should have been able to send the mail out. It may very well have been denied. The question was, I believe the question is, did his First Amendment rights really have to be violated in order to comply with the policy?
So let's assume the policy says, which is what I think it says, that inmate-to-inmate mail, A, has to be approved, and B, quote, may always be inspected and read by the staff at the institutions.
I'm assuming.
Are you saying that's unconstitutional?
I'm assuming after it was, I'm thinking that means after it's approved, it may be inspected, because if it's not approved, it's not going to be sent. But again, like I say, it's selectively enforced in this instance, which I think is again is a violation. One person is allowed to do it, and another person is not allowed to do it. But I think
so there's two pieces of correspondence, and you're saying because one was intercepted and one wasn't, there was some constitutionally inconsistency here?
Well, I don't think this Constitution should be selectively enforced. It should be for all people. He received a letter from his girlfriend, who was in the female.
So when he received it, that's contraband, right? He had no right to receive it. She had no right to send it. It shouldn't have been there. So that would be contraband. So the one he had in his cell.
I don't believe mail fits under the definition of contraband, but if it does, they allowed it to go through the system to get to him.
Somebody screwed up. Happens. Somebody allowed it to go through.
Right, so it appears as though the First Amendment, it seems to depend on who you get. So like I say,
The second piece of mail, the mail that he sent to her,
was intercepted.
yes, it was addressed to her,
It was addressed to her.
and the actual sender's address was her also.
It was her also, but there was no question for Lieutenant Miller who was sending the mail. And there was no question because he put number 505, which belonged to the defendant.
So 505, is that a room, a cell number?
It's his little cell number in the pod.
And how many, okay, so how many people are in 505?
I believe there were one.
One person.
One
So
person.
he put on it 505 because presumably he took it from, it was left on the windowsill of that pod or cell.
No, it was left on the windowsill of the whole pod, yes. Or you could put it under your cell. But this one was left on the windowsill. It obviously came from the mail pod. He put 505. Another inmate called down and said, you know, they got your mail. So there was no question that he knew that it came from. And he looked on the computer. I forgot that part. He looked on the computer and he could see that they were co-defendants.
So this right away is suspicious. Why would he put someone else's return address on there? Why wouldn't he put his own name on there? Doesn't that in and of itself make this somewhat concerning? What's going on here?
Yeah, you know,
I don't know. Seems odd.
No,
I think and unfortunately, I think it was just a human, it wasn't meant to be anything insidious or anything. It was just a human error.
Okay.
He was quite smitten with this girl and received a letter from her. And I mean, he was a young man, 19 years old, so I don't, you know. But like I say, I think the gist of this argument is that there's an easy accommodation here, which is to walk a few steps, give the letter back, and say, this can't be sent without prior approval.
No,
There was nothing that indicated there was any threat here, and again, they acknowledged that it wasn't confiscated because of any threat.
No, I have a note which indicates that when inquiry was made as to whether he had sent it, he did not admit to having sent it. Is that correct?
I don't recall that he didn't admit to it. I honestly don't recall that. I think there was no question that it came from that pod.
Could I turn to your second argument?
I'm sorry?
To your second argument?
Yes, I'm going to hit.
Well, one question is, are you suggesting that there was that asking for an instruction on manslaughter based on accident
Right.
is different than your third argument about ineffective assistance of counsel, where it's manslaughter based on wanton and reckless misconduct?
I mean, I believe this, you know, and the second argument was that the judge should have given an involuntary manslaughter based on wanton and reckless conduct. It wasn't that there should be
So when the lawyer asked,
right, she was, I believe she was asking for the right instruction, but the wrong reason for the instruction. That it's hard to get in, yeah, argue an accident when someone is alleged to have put a
well, it
gun
seems to me
in the
it's a
car.
subset of the wanton and reckless. That is that it was wanton and reckless to have the gun, and it accidentally went off. So I mean they go
Right,
together, right?
right.
But so they're basically the same. Only, well, I'm not clear. If it's an error of the judge not to give it, but it's also ineffective assistance.
It's an error not to give the instruction based on wanton and reckless. It's ineffective to not frame the argument in the correct way, because if there's an alternative view of the evidence, and I think there is in this case, then you're not bound by the felony murder where you can't get the manslaughter instruction.
Okay.
So I think that there is an alternative view of the evidence, mainly because
But
of...
if the jury found, as they did, your client guilty of assault with intent to rob, correct?
attempted robbery, so it's...
No, well, that wasn't charged. That wasn't the charge assault with intent to rob?
He was charged with armed assault with intent to rob, which was dismissed later because that's the second
Well, I understand that,
degree.
but the jury found him guilty of that, right?
Right,
So my point is, the jury found him to have had the intent to rob.
right.
So doesn't that affect the question about the wanton and reckless?
If I could just briefly, I know I'm almost done here, or done, but I think the main problem in this case, if you read the brief, it's an identification defense. And that identification defense with the letter was just, was not credible. And I think the jury, being like human beings, if you focus them on something that they don't find credible at all, they're just going to reject it. It's like putting a defendant up who's not credible at all. It becomes a contest of credibility versus not credibility. So it was a defense which was not credible. So any analysis of anything else, it's difficult to do. And I think if you read the brief, you'll see that the co-defense attorney was sort of the lead attorney in this case. And of putting a defense that's not credible, it really becomes, well, was it him or wasn't it him? And any other analysis, it really is, I believe, difficult for the jury to reach. When it becomes
Co-defendant was found not guilty of everything?
He was found not guilty of everything because there was really very little, if any, evidence against him. Whether it was he was found not guilty because they didn't believe he was there or because they didn't believe he did anything, it's hard to know. But there was very little, if anything, any evidence against him. So I think that was the problem with that when it becomes that kind of contest, it's hard to move through an analysis of everything else.
Thank you, counsel.
Good afternoon. May it please the court, my name's Deborah Alstrom. I'm an assistant district attorney in Hampden County, representing the Commonwealth this morning. If I could just go back to the first issue for a minute to clarify the sequence of events, because I think there is some confusion, and there was some confusion, I think, in the testimony. But the letter was in the common area of this pod. It was addressed to Nixon, and the return address was Nixon. The Lieutenant Miles
It wasn't on the
Picton-
windowsill, or the windowsill was part of the common
The
area?
windowsill was in the common area. There was no person named Nixon in that particular pod. And so Lieutenant Miles took the letter, and first of all, he considered it contraband because there was no person by that name in that pod. He took it into wherever his little office areas or whatever, and he looked to find out if there was a Nixon in the pod. There was no Nixon. Then he said he opened the letter to find out who was sending the letter. And either from the name Anthony inside the letter, or because he checked his maybe checked that against his list. But anyway, he went back out and called the defendant's name. The defendant didn't answer, but somebody else in the pod did alert Mr. Jessup to the fact that the officer had taken his mail. So it was considered contraband because there was nobody there in that pod by that name, and also because it was something he was not allowed to have. It was opened to see who had sent it, and it was read because it was contraband, and it was considered contraband.
It wasn't something he was allowed to have because it wasn't clear that he wrote it.
It
right?
wasn't clear that he wrote it until it was opened and read, and because the policy was that there could not be inmate-to-inmate correspondence.
Without
I
prior-
think even outside of a family member, without permission. They were given this information when they came into the jail, so he knew. He was arrested on the 2nd, and the letter was picked up on the 17th. The question of whether this was selectively enforced is really not before the court. There was no evidence about what happened to Miss Nixon's letter when it came, when it was sent to him. So I don't think that's an issue here. But the policy itself was established over the years in the federal cases of Procunier versus Martinez, Turner versus Safley, and Thornburg versus Abbott. And this case in Massachusetts Prisoners Association Political Action Committee versus the acting governor did adopt Turner versus Safley's deferential standard of review when it came to regulations that impinged on a inmate's rights. And Safley established that inmate-to-inmate correspondence was of a heightened security risk for various reasons, and upheld, in that particular case, restrictions on inmate-to-inmate correspondence. And I would suggest that the same is the case here. Not only was it inmate to inmate, but Lieutenant Miles, when he reviewed the names in the I assume, a computer, found out they were co-defendants, and he said, in his mind, although this was not the reason for picking up the letter or reading the letter, in his mind, this heightened his concern about the security. So I would suggest to the court, because the policy established was for the order and security of the penal institution, which the cases in the past have said is appropriate, and this court has determined should be deferential to those who run the organizations to determine what might be questionable to the security of the institution. I would suggest that the policy was a valid policy. It was a content-neutral policy, and that Judge Sweeney, although her findings were not overwhelmingly exact or complete, but she did the appropriate thing. She found that it was a security interest of the penological institution, and as a result, she determined that the letter should not be suppressed.
Now, am I correct that it was not learned who the letter was from until it was opened?
That's my understanding from reading the testimony in the motion to suppress.
And did
I've
Judge
read it
Sweeney-
a number of times because it was confusing.
And did Judge Sweeney make that finding?
She did not make that specific finding. No, her finding was very general. She said something about there was mail going back and forth, and that it was restricted, it was opened because of the security. So it was, this motion to suppress was denied.
So the issue before us need not necessarily be whether all inmate-to-inmate mail may be opened without prior approval, but whether inmate-to-inmate mail without prior approval may be opened where the identity of the sender is not known.
I don't
Or is
think-
not revealed on the.
Well, that is just one of the two reasons that the officer picked up this mail. And I would suggest that that does not have to be the dominating concern here before the court.
What should be the dominating concern?
In regards to the request for involuntary manslaughter instruction, the Commonwealth's position is that the issue was not preserved. It was mentioned fleetingly by defense counsel. She asked for instruction because she said the gun went off accidentally and that there was no robbery or attempted robbery. And it was left at that. And that was early on in the discussion of instructions. There were at least two subsequent charge conferences at which it was never raised again, the issue of involuntary manslaughter. And in the final analysis, when at the close of the judge's charge, and he asked the attorneys if they were satisfied with the charges as they had been given, defense counsel did agree that she was satisfied. So I would suggest that there was no evidence no factual evidence to support the giving of an instruction on involuntary manslaughter. And certainly in this case, there was no prejudice to the defendant, since the jury found him guilty of murder in the first degree, and they also found him guilty of the armed assault with intent to rob. And that's an inherently dangerous felony. So I would suggest to the court that there is no basis for involuntary manslaughter here. There was no evidence that the gun went off accidentally, and there's no real theory that the defendant has put forth to support an involuntary manslaughter instruction. I mean, the only possible thing they could be hanging their hat on in that regard would be that the car moved and somehow caused the gun to go off. But again, he was found guilty of the armed robbery. So this case has said before, and I guess the most noted one is Evans, that if a gun goes off accidentally in the course of an inherently dangerous felony like a robbery, it is of no consequence. So I would ask your honors to affirm the conviction in this case. And
Was the jury instructed on a theory other than felony murder?
no, there was a request for premeditated murder, and because early on in the case the Commonwealth had not put forth that theory, the judge denied the request
Oh,
for that.
I was wondering why he did, yeah.
Yes,
okay.
I requested that, and he refused.
Can I ask you, I feel badly now, I was cross-examining your sister based on the wrong regulation, because you've got federal regulations, mass
yes.
regulations, Virginia regulations, all.
I included the regulations because they consistently place restrictions on inmate-to-inmate correspondence. And usually the exception is for family members that are inmates, and then usually there is, and I don't have them in front of me, and that's why I'm saying usually there is some other exception, but it's usually subject to review by somebody in the institution. Somebody is given permission to look at it before it's transported.
All right, and so the Virginia regulations that you've included here, I only see two of them.
The Virginia regulation that I included in my addendum is not the one that was presented at the hearing.
All right.
That was just a general one that I found and included in the addendum.
But the federal one, which basically says correspondence between inmates may always be inspected for
Correct.
security reasons.
Correct.
Is that, I take it, was that the one at stake in Turner versus Safley, or no?
I believe so. I believe so.
All right.
Yes, that was the one that was noted approvingly, I think, in Turner versus Safley.
Thank you.
And if there are no further questions, I would rest on my brief. Thank you very much.
Thank you, counsel.
All right.